I can't remember what I was talking about. So a body of law developed throughout the West, and it's pretty much the same in every state west of the Mississippi. But a body of law developed that looks a whole lot like all the other bodies of law that were being developed at that time, and that was really a body of law that promoted capital investment and entrepreneurialism, supporting the development of natural resources and the exploitation of natural resources all across the West. So if you look at oil and gas law or mining law or timber, forestry types of laws, all those policies and laws as they developed are really designed to try to promote people to spend their money and create investments in something. And once they put that money to use, or that natural resource to use, then they basically got a vested interest or a right, or in some cases a property right associated with the use of that natural resource. So if you were the first person to go drill an oil well out somewhere or go mine for gold up by Helena or whatever it was, so long as you continued to use that new well or that mine or that water appropriation, you got to continue to use it. That's how railroads were built in this country. That's how irrigation ditches were built. That's how big logging operations started. And the United States would basically say, hey, if you went out and made this investment, then we're going to reward you with something to be able to keep and use as your own. And every state sort of followed suit on that front. But everybody sort of forgot about the fact that there was this case that had been decided by the U.S. Supreme Court that said, but for Indian reservations, there was implicitly enough water left or water reserved to fulfill the purpose of that reservation. So while all this stuff is happening and water's being put to use, and people are assuming that they're getting water rights that attribute back to when they first started using it, nobody thought to deal with the fact that there were water rights out there, those held by Indian tribes, that didn't line up. They didn't fit together. They were two Legos that wouldn't connect. And so the body of law basically says that water rights, regardless of what kind they are, is what we call a first in time, first in right, or seniority based system. So the first person on a stream to put water to use has the most senior right on the stream, and they've got the right to stop other later or more junior appropriators from diverting if their use of the water interferes with that person who owns the most senior right. So then what ended up happening is half a century or so later, disputes started arising, particularly in the Southwest, where there's a little less water and things are a little more tight when it comes to water. And really this fight really arose out of disputes between the states of Arizona and California on the Colorado River. And that resulted in litigation sort of going lots of different directions. And Montana, I think, at least in my opinion, had a little bit more foresight than a lot of other states, to the extent that they recognized that litigation didn't really get anybody anywhere. You spend, in some cases, centuries fighting over who has what rights in court. And at the end of the day, everybody gets a piece of paper that says, here's what you own, but no real resources or capability to do anything with that piece of paper. And everybody had spent tons of money and resources. And in the meantime, they weren't able to be productive and use water necessarily while the courts were figuring it out. So Montana established an entire set of rules associated with water usage that generally track this first in time, first in right seniority basis. But in the process, they said we should deal with the fact we have 7 reservations in Montana that consist of millions of acres of land, and potentially a lot of water. And so we should have a process where the tribe and the state and potentially the United States can sit down and negotiate an agreement rather than go through a lengthy court battle where at the end of the day, two sides get 2 pieces of paper that don't really do them much good. And all they had to do was look across the southern border of Montana into Wyoming to see that that's really not a good solution to just litigate. The state of Wyoming litigated with the tribes on the Wind River Reservation for decades, and at the end of the day, the tribes have significant water for irrigation use, even though the tribe doesn't exercise or doesn't engage in a lot of irrigation. They've got a project that in some ways is similar but much smaller than the project here. And there was no money to fix it up. There was no way to get the tribes water that they wanted for things that were important to the tribes. There was no money to address ongoing needs, and there was really no way to fix problems as they arose going into the future. And so the leadership in the Montana legislature at the time decided to create this negotiation process. And at the time, tribes didn't have any involvement in it really to speak of. They just sort of were advised of the fact that, hey, we created this process to negotiate with you, and if you want to negotiate, feel free to stand up and negotiate. So the first tribe is the tribe where I'm from. Fort Peck was the first tribe to stand up and say, yeah, we'd like to negotiate a water rights compact with the state. And that was, the negotiations were completed and the compact was signed in 1985. And very different scenario over there. The reservation is bounded on three sides by water bodies, three rivers, streams, much the opposite of the Flathead Reservation, which is bounded on three sides by three watershed divides and not streams. And so CSKT was the last Indian tribe to go through that negotiation process. And now the state has successfully concluded negotiating agreements, not only with all of the Indian reservations and tribes in the state, but also all of the other federal reservations, such as the National Wildlife Refuges in Montana, the national parks, and the national forests, to name a few. So it was a process that basically allowed for the parties to sit down and negotiate something in settlement, and then they didn't limit it to what could be achieved in court, which is generally the way settlements work in legal disputes anyway. So if Rob, Rob and I get into some kind of dispute, he runs me over with his car, and my leg's broken, and I decide to sue him because I want some money to fix my leg. At the end of the day, if we want to reach a settlement, and that settlement says, I want Rob to write me a letter saying, I promise to quit being such a bad driver and quit talking on my phone. I'm saying this because I was talking to him on my phone when I was driving here just not too long ago. And he's going to sign that letter, and that's going to be included in part of the settlement. That's something I can get from Rob and feel really good about myself that he finally apologized to me for running over my leg. Something I can get in settlement, but that's not something I can get in court. If I go to court, if I take him to court, all I can get is money damages, right? I can just get a check. And so the same is kind of true in water rights adjudication. You can get a piece of paper that says this is your water right, but you can't get anything else with it. You can't get any money with it. You can't get a thank you note. You can't get a I'm sorry note, nothing like that. So when the settlement process or the compacting process began, there were really no limits to what tribes could agree to. And although the first 6 reservations and tribes that went through the process followed a very similar pattern, the Salish and Kootenai tribes and the Flathead Reservation was significantly different and had a lot more complexities here relating to water than anywhere else. And I named one already, the fact the reservation is bounded on 3 sides by watershed divides as opposed to by water bodies. But some of the other differences that exist here that are not found on other reservations is you have a massive federal irrigation project, the Flathead Indian Irrigation Project, that irrigates roughly 130,000 acres of land, has over 1,000 miles of canals and about 10,000 structures, and is about 40 to 50% efficient on any given day, meaning that 50 to 60% of the water that's diverted or pumped for the project never actually is able to be used to water a crop. It's lost through evaporation or seepage, or is made available at a time when it can't be otherwise used. And so significant amount of that water that's diverted out of streams isn't actually able to be used for irrigation purposes. In addition to that, on this reservation, the majority of the water that's actually put to what we refer to in water law as a beneficial use. That just means water is being used for a some purpose, and it's a legal sort of term of art. It can be for irrigation, it can be for mining, it can be for industrial uses, municipal, for domestic drinking water, watering livestock, and it can also be left in the stream or water body for purposes of fish and wildlife habitat. Those are all types of beneficial use. And so the majority of beneficial use on this reservation really runs through the irrigation project, which is significantly different than most of the other reservations in Montana. But most of that water that is used actually originates on tribal land, as opposed to all the other reservations in Montana. Most of the water is arising off the reservation, up in the mountains over here somewhere, and then it flows down a river many hundreds of miles in most cases before it finally reaches a reservation. And usually for most of the other reservations in Montana, that river, as it approaches the reservation, is actually the border and not running through the middle of the reservation. So there were just a lot of one other important distinction here as well is that if you look at a land status map, which I'm sure a lot of you've seen, the tribes put them out, there's tribal land is depicted in green. It looks like almost like a donut, right? The reservation is sort of bounded with a big ribbon of green. Most of the tribal land on the reservation is around the perimeter, and most of the non-Indian fee land is located in the center part of the agricultural valley lands. So all of those were complexities that didn't exist for most of the other tribes in Montana. And so whether that was the reason or whether there were other reasons, the state was slow to get to CSKT from a negotiation standpoint. So CSKT was really the last tribe to go through that process, which had certain benefits associated with it, in the fact that the state had invested a lot of time and resources in the ability to analyze and evaluate water rights on all the other. You got to practice a lot in other places before it finally came here. Given all of that context, the tribal negotiating team, and I hadn't gotten here yet, but there are some folks that are in the room here that were a part of that team. Mary Price is one of them, a former colleague and boss, Rhonda Sweeney, obviously, Dan Decker, Seth Makepeace, who will be here in a minute, and many others participated in that process. But what they really tried to accomplish, I think, coming in, looking at it from the outside, is they tried to take advantage of that little concept I mentioned earlier, is that you can achieve things in settlement that you can't achieve through litigation, right? And so they tried to look at all of the things that made this reservation different or unique or were important to one group of people or another, and tried to create a scenario where there didn't have to be winners and losers, right? The idea was that there would be potentially a way to preserve existing water uses on the reservation, while at the same time ensuring that the rule that was set forth in that old Supreme Court case at the turn of the last century, U.S. versus Winters, actually carried through, and that there was enough water reserved back in 1855 when the reservation was created to fulfill the purpose of the reservation. And in this case, the purpose of the reservation, and this is language straight out of the Hellgate Treaty, is to be the tribe's permanent homeland. So a permanent homeland is exactly what it means, something that a place where people can make their homeland in perpetuity, forever and ever, and that requires a certain amount of water for people to drink with their supper, for them to water crops and gardens and lawns, to build factories and orchards and to do cultural activities and all those types of things that you associate and you need water for. All of those are included in the permanent homeland standard. So after really decades of negotiation, the negotiating teams between the tribe and the state were finally able to reach an agreement that was then memorialized in the CSKT Montana Water Rights Compact, which is approved by the Montana legislature, excuse me, in the spring of 2015, April 24th, right, Dan? 24th, 26th, 24th of 2015. And it was controversial, I think is probably the right word to say. And the controversy, it's really hard to put your finger on what ultimately was the rationale for all of the controversy. But one of the things that folks like to talk about that they say was different with this compact is that it included off-reservation water rights. Well, it's not actually accurate to say it's the first and only compact to have off-reservation water rights. I think all of the other compacts do, but most of them certainly do. In fact, where I'm from, Fort Peck has 1,050,000 acre feet of water that they can use out of the Missouri River, and that includes diversions out of Fort Peck Lake, which is 30 or so miles upstream of the reservation. Am I getting out of your screen? I'm sorry. Okay. So whether that was a red herring or not, we don't need to get into it, but the moral of the story is there was a little bit of controversy, and so the ratification of the compact was kind of a big deal because it had not been ratified by the previous legislature in 2013. And some of the basic components of the compact, which folks at the individual tables will be able to talk to you more about, but it included all the things that both the tribes and the state negotiating teams thought were important and met the sort of basic requirements of a water rights compact, and that was to quantify the tribal water right, so that there could be certainty among water users on the reservation, and throughout the tribe's Aboriginal territory. So at the end of the day, that's what the compact is. It's a quantification of tribal water rights. It doesn't do anything with regard to anybody's individual water rights. So if you're somebody that uses water and you made a water rights claim way back in the 1980s, the compact doesn't speak to your rights at all. It only speaks to the rights of the tribes. But it does have an important component that is a little bit different than all of the other compacts in Montana, and that is with regard to the administration of water after the compact's effective. And that's what we refer to here as the UMO. You may have heard recently that the Water Management Board was recently formed. They've had a couple of meetings, and they appointed their 5th member, and they're getting up and running. That is the administrative and quasi-judicial body that will ultimately make determinations on new water rights permits and appropriations, will resolve disputes between two water rights holders who have a difference of opinion as to whether or not their one water right is senior or junior to another, and it will also be the entity that will serve as the holder of the documents. So basically kind of like your clerk and recorder or the DNRC off the reservation for water rights. It's a place where everybody can go and say, where's my certificate, to see whether my water right's better than my neighbor's, how much water do I get to use, all of those types of things, just like you would register your car at the DMV, or you'd record your mortgage or a quitclaim deed or a warranty deed at the clerk and recorder's office. The Water Management Board on the reservation will serve that purpose. Now, I said it's a little bit different than the other reservations, and the reason it's a little bit different is that for I guess for all of the other reservations in Montana, beginning with Fort Peck back in 1985, the state and the tribes thought, well, rather than have a situation where everybody puts everything in one place and then tries to figure it out from there, wouldn't it just be easier if the tribes regulated and administered water rights among Indians on the reservation, and the state did the same, excuse me, for non-Indians? And then if there's ever a dispute between an Indian on one hand and a non-Indian on the other, we'll have a dispute resolution board that will be made up of people appointed by 2 or 3 representatives from the tribe, 2 or 3 representatives from the state. They get together and make a decision, and that's the final decision. Because of the uniqueness of this reservation, though, that kind of a concept really didn't make sense, because, as I said, most water, 87–90% of the water, arises on tribal lands that's actually put to use on the reservation. And most water starts on tribal lands, goes down into a federal irrigation project, a lot of it then gets distributed to non-Indian water users, to some Indian water users as well. And then much of it then returns up, sometimes up to 50% of it returns back to the Flathead River system on there again on tribal lands before then it finally leaves the reservation. And so the nature of how water moves here, as well as this massive irrigation project that sort of sits as a barrier in between that water use, as well as the demographics and land ownership status on this reservation, made the negotiators think, you know, having a situation where the tribe regulates on one side and the state regulates on another isn't maybe the best idea, because at the end of the day, every dispute is going to have to end up going to this sort of dispute resolution board that then is created and exists for every other reservation. So rather than have that type of a system, what they negotiated and came up with is a unitary management ordinance where the tribes and the states basically agree to have the same set of rules, and that same set of rules applies to everybody, whether you're Indian or non-Indian, tribal member or non-member, whether you're the tribes or the state of Montana, doesn't matter. Everybody follows the same rules. And rather than have a dispute resolution board that maybe gets used once in a while, we'd have a board that ultimately oversees the registration and administration process from sort of start to finish. And that way you've got sort of a one-stop shop to deal with if there ultimately is a dispute that has to happen. So very uniquely, and something that doesn't exist anywhere else in the country. It's a one-of-a-kind, first in history kind of process. And so where things are at right now on that front is that the tribes and the state both nominated their two appointees. They were then appointed and confirmed, and they just started meeting here a month or so ago. And the deal is that the tribes would appoint two, the state would appoint two, and then those four people together would appoint a fifth person to make it a 5-member board, along with a federal ex officio non-voting member. So it's up and running, or getting there. And there's folks on from both the state and the tribes have been doing just amazing work getting that stood up. It's a little bit of a hiccup that we sort of knew was going to be a problem, well, not a problem, but a hiccup in any event. And that was I'd said before that the compact had been put together and taken to the 2013 legislature and didn't pass. In the process between the 2013 and 2015 legislature, to deal with one of the complaints about the compact as it existed in 2013, the Attorney General's office actually came to the negotiating table and said they didn't like the way the process for the appointment of the Water Management Board was made, and they wanted to make sure that the state appointees could have some local input. So they negotiated sort of at the 11th hour a provision where the county commissions from the 4 counties on the reservation would nominate several candidates that would then ultimately get selected by the governor, so that it didn't just allow the governor to just pick whoever he or she wanted. So that change sort of came in at the 11th hour going into the 2015 legislative session. And in order to ensure that, you know, a governor from one political party didn't necessarily appoint people just on straight party lines. So, but the byproduct of that is that it had to allow for the county governments 90 days from the date the compact was ultimately signed to submit names, and then gave the governor another 90 days. So it took a little bit longer than it might have had that provision not changed in the compact between the 2013 and the 2015 session. Otherwise, outside of the regulation part of the UMO, like I said, the purpose of the compact was to quantify the tribal water right. And the tribal water right is the term we use to describe all the water rights, plural. We say it's singular, but all the water that would be used by the tribes now and going into the future. And that includes several categories of water. And there's been a lot of information put out there about this, but one of the big ones is enough water to continue the operation of the Flathead Indian Irrigation Project. Now that's a water right that's held by the tribes, held in trust for the tribes. It has a priority date of 1855. That was the date the reservation was established by the Hellgate Treaty. which is the second oldest water right you can have on the reservation. And so what that did is basically allowed for there to be a continual supply of water for the irrigation project into perpetuity. Without that provision in the compact, without the tribes agreeing to basically hold, to be the beneficial owners of that water right, there was a concern that the irrigation project would have had to have gone through the same process for establishing a water right that other irrigation projects have in Montana, which is basically a priority date system, whereby every acre that's served by a project would conceivably have a separate and different priority right. And for any of you familiar with the project, you can probably surmise that it would be nearly impossible for the project to deliver water on a priority basis between two landowners based on when the water first started serving any particular acre or piece of property. So that's a significant, what we call consumptive use of water. It's a beneficial use of water for irrigation purposes. In addition to that, there's some additional water that is reserved to the tribes for future irrigation uses, as well as irrigation water that does not run through the irrigation project, but serves Indian or tribal lands. There's what we call in-stream flows and minimum reservoir and lake pool levels, which are there to and designed to be protective of fish and wildlife habitat on the reservation. And there's water for domestic, municipal, and industrial purposes. DCMI is the acronym we use: domestic, municipal, I'm forgetting one. What's the C stand for? Commercial and industrial purposes. And there's a specific water right that's really intended to be for future uses for all of those purposes, and that's a consumptive right out of the Flathead River system. And that water right includes storage rights that are for water that's held in Hungry Horse Reservoir. And that creates a really cool little function. For lots of places in Montana that are growing, like Bozeman and the Gallatin Valley, they've gotten to a place where there's not enough water for the development that's happening, and they've had basins that have been closed, and there's really no ability to go out and get a new water right. And so any new, like if somebody wants to put in a subdivision or build a shopping mall, if they want to apply and get water rights, they've got to find a way to offset it. And that's a really challenging and expensive way to do things. And just north of here, we have the potential for the same thing to happen in the Flathead Valley. And what one of the things that the Hungry Horse storage right does is open up the ability for mitigation water for when the Flathead Valley starts to run out of available water. They can mitigate water that would otherwise be stored in Hungry Horse and then actually just dished out and left and sent down the river into Idaho, Washington, and Oregon. So it was able to, so through the quantification of the tribes water right, the tribes were able to basically work together with the state of Montana to ensure that development could continue to occur in Western Montana in the headwaters of the Columbia River, and keep some of that water that would otherwise just go down and make its way to Portland. So the water rights are all laid out in the compact. There are abstracts that are actually attached to the compact, and going forward, all of those water rights will eventually be recorded with the Water Management Board under the Unitary Management Ordinance, just like every other type of water. And one of the things that's really unique here is that the tribes agreed to follow the same rules as every other water rights holder on the reservation. That's not found in any other case. In any other reservation in Montana, most tribes reserve the right to be able to use water without having to go through any particular process. But what that allows for is that it protects everybody who's already using water by ensuring that new uses of water go through what we call an adverse effects analysis. To say, if you're going to drill a well next to me, a mile down the road or 100 feet down the road. As somebody who's been using water, it'd be nice for me to know if you're going to be draining my well when you poke that hole into the ground. And so that's what the tribes agreed to, and that's what the state agreed to. So that's the rules that everybody will follow. And it really is designed to make sure that we don't get into the fights and disputes that have happened in other places across the state and across the West, really. But in order to make all of the water rights sort of work together, where consumptive uses like water being used in the irrigation system to jive with water rights that are supposed to stay in the stream for fish and wildlife habitat, one of the things that the negotiating team knew is that the only way that that could really happen is if there was an infusion of, is that my time? I'm done. Cut him off. It's better than people just falling asleep on me. It's nice, like woke everybody up, right? I don't know how I always get this 3 o'clock hour where people are trying to fall asleep. But in order for things to work together, the negotiating team knew that there was going to need to be resources that were brought into the deal, right? And those resources would have to be used, at least in part, to do rehabilitation to the existing irrigation project that's here and to modernize it in some ways, because there's really no way under its current condition that, number one, it's going to survive for too much longer. It's 100 years old and really hasn't had a lot of work done to it over the course of more than 100 years. But in addition, it was designed using 1800s technology, so it's not the most efficient thing in the world. And if we're really going to meet the objectives and goals of the water rights that are set out in the compact, there would need to be some work done to it. Basically, it need a little bit of an overhaul. In addition to that, there was, when the project was originally constructed and going forward throughout time, the continued operation of the project has caused damages to tribal natural resources, to tribal lands. It's caused massive erosion. It's created challenges for water quality, for fish and wildlife habitat. It's killed people. I mean, it's a big piece of infrastructure that needs a lot of attention. So after the compact was ratified by the state legislature in 2015, the next step in the process was to get the compact actually ratified by the United States. And even though the United States had a team that was involved in the negotiations and sat there, at the end of the day, only either the Secretary of Interior or the United States Congress had the authority to actually sign off and approve the compact. And the only way to actually get any resources, any money to deal with the problems and try to build upon the ideas that the negotiating team had in developing the compact was to have it approved by Congress. So beginning in 2015, the tribe set out to seek federal ratification of the compact. And at that time really sat down and did an evaluation of the best way to accomplish that and what it should look like. So the tribes went through an evaluation to determine the level of damages that not just the irrigation project, but any actions that the United States had taken since 1855 that related to water that might have caused damage to the tribes or tribal natural resources. So they went through that sort of due diligence process and said, okay, here's all the things that we think didn't go right, that should be rectified in the water settlement. Why did they do that? Well, the reason why is that Congress only approves Indian water rights settlements if Congress can be assured that the United States is relieving itself of any of liability relating to water that the United States may have. So with every Indian water rights settlement, Congress has required that the tribe that settles their water rights release the United States from liability. So if you go back to the example of Rob running over me and breaking my leg with his car while he was talking on his cell phone, if I'd have sued him for doing that, and his good neighbor State Farm came into the picture and said, hey, we insure Rob McDonald. We know he's a shitty driver, but he pays us our premium every month, so we're going to defend him on this action. And they said, we've seen you, run and try to play basketball. Your leg's not worth that much. We'll give you $5,000, and we'll give you this check right here and now. Here's a check for $5,000, but you have to promise, if you take this check, you're going to drop this lawsuit against Rob, and you're never going to sue him again. You're not going to sue his wife. You're not going to sue his kids. You're not going to sue State Farm. And if you do that, if you sign a piece of paper and say you're releasing us from liability, then then we'll give you this check. That's kind of the same way it works with Indian water rights settlements. It's a little bit different because the way Congress deals with Indians is that they take it a step further. They say, well, as long as you release the liability and you can have the check, but you got to spend the check on stuff that we say you have to spend it on. That's an old attitude the United States has had towards Indian country for a long time, a little paternalistic, whatever. Those were the rules. That's how we played the game. And so we knew what we thought the damages were. We've gone through the due diligence process, but that's all fine and good. But at the end of the day, I mean, you guys have heard the phrase, "Oh, that'll take an act of Congress," right? Well, there's a reason why there's that saying. It means it takes a little bit of work, right? It takes some time. Sometimes it can take decades to get things through Congress. Luckily here, the tribal council was willing to dedicate the resources and attention it needed to really not let it take decades. But back in 2015, we said we need to put together a proposal that actually has a chance of getting passed. We can't just walk out and say, well, we want $100 billion like Dr. Evil and hope it happens, right? Because we didn't have a rocket aimed at the moon or anything. And so what we did, and this is based on success stories in the past by other tribes, water and not water related. We looked at all of the potential water related liability that could exist in the United States, but we also looked at the potential of what development of water on the reservation could do, and that which was feasible. And so obviously with the irrigation project, there's a lot of potential, right? There's a lot, you guys are, a lot of you here, I'm sure, are familiar with the project. There's a lot of room for improvement, but not everything related to the project is feasible. The same is true for most every other type of water use on the reservation. Most of the municipalities on the reservation, Polson, Ronan, et cetera, have water systems that deliver water to their residents. They've got wastewater systems that deliver water to their residents. Some of them are old and falling apart. Polson's in the process of building a new wastewater system or somewhere thereabouts. So we went through and did an analysis of kind of everything that exists on the reservation, Indian, non-Indian, whether it's run by a municipality or by the tribes or individual. And we said, okay, what can we do with resources? What's feasible? And at the end of the day, that's what the tribe's original settlement proposal to the United States is here's a list of everything that we think is feasible, that we could do if we got everything, all the resources that we wanted, that could be put to work to fix all the things and build all the things that are feasible. That's what we opened up as our original opening offer. And for those of you that were around in 2016, you might remember there was a bill that was introduced in Congress by Senator Tester that proposed a $2.3 billion water settlement. That was based on a proposal that we'd put together based on everything that was feasible related to water. And at that time, the standard operating procedure was that a bill that approved a water rights compact had to basically break out every single dollar into what it was going to be used for and call it out specifically. So that's what we did. But with Indian water settlements, Congress and the White House de jour of the day sort of changes the rules as they go along in certain respects. And so that's one of the things that changed while we were working through the process, is that the United States decided that having federal legislation that put money into a bunch of different buckets wasn't a way that they wanted to do to this settlement. And that really relates to inflation, which is something we're all kind of feeling right now with everything that's going on in the country. But the notion is that if Congress says we are authorizing the tribe or somebody, the BIA, whoever, to go fix this project or go build this project or do that, they can say, we think today it's going to cost $100, but it's going to probably take us 10 years to do it. By the time we're done building it, it's probably going to cost more like $200 because the cost of materials for doing that project are going to increase over time, or at least they have for the most part throughout most of America's history. If you go back to like 1900 all the way up to the present, on average, there's been inflation at about 3% per year, and that includes the Great Depression as well as the crash in 2008 and 2001 and what have you. So we know it's probably going to cost more. And the United States said, look, we've got several of these projects in Indian water settlements around the country where we thought they were going to cost a certain dollar amount, but we never got around to actually paying for it like we thought we were going to. And now it's costing us way more money. We've got to go back in, open up the legislation, extend the period that it's authorized for. This is really exciting stuff, isn't it? I know you guys are like, when can we get to the tables? So they changed it and they said, we don't want to do it that way. We want to do is just give you one lump sum amount of money, list out the authorized projects, and we'll escalate the amount of money that's actually transferred based on inflation from the date the settlement's approved, and then you go figure out how to do all the work. So that's what they did, and that's what the tribal council agreed to. At the end of the day, legislation was signed in December of 2020 by President Trump as one of the last acts he didn't as president. He signed the Consolidated Appropriations Act of 2020, which funded the government for 2020 and 2021. And it included in section DD, the Montana Water Rights Protection Act, which ratified the CSKT Water Rights Compact from the federal perspective. It also provided the federal contribution to settlement, which was $1.9 billion, and directed the Secretary of Interior to approve the Unitary Management Ordinance. The reason why I kind of digressed in the way the funding is set up is because it's important at the end of the day. When people read in the paper, oh, Congress approved X amount of money to go do something, you know, they sort of assume it's like normal people. Like when you say, I'm going to write you a check, that means I'm going to write you a check and you're going to go spend it, right? Well, that's not how the government works. Probably no surprise to any of you guys, right? Usually what Congress does is they say, we are going to authorize an amount of money to be spent. That's like, I say to my wife, I'm going to go run downtown for a little while. And she says, okay, you can spend $20. That doesn't spend the money. That just gives me the authority, right, to spend the $20 that's in my wallet when I get to the establishment I intend to go, right? The other part to it is Congress actually then has to appropriate the money. So in the example of my wife telling me I can spend 20 bucks, her actually handing me the $20, that's the appropriation part, right? For most Indian water settlements, and there've been about 30 approved since they started doing this in the 80s, 70s, 80s. In most cases, the settlement was enacted and Congress authorized the money to be spent in whatever dollar amount it was. But then they took, in some cases, 30 plus years to getting around to actually appropriating the money, actually writing a check and handing it to the tribe or whomever was supposed to get it in the settlement. So when we were working on this, we were like, that's not going to fly, particularly not with a price tag of $1.9 billion, which at the time, well, it still is the largest Indian water rights settlement in history. That's going to take 100 years, right? I mean, because we know of Indian water rights settlements that were only $100 million that took 30 years to pay for and still were in the queue to not. And the big catch is with Indian water rights settlements generally is that the United States usually says you can't spend any of that money until we get done appropriating it. So we're going to say we're authorizing it. So it's like my wife telling me you can spend $20 and I'm going to give you a penny at a time until when I feel like it. And then once you get the $20, you can actually go to the establishment and spend it, right? So in my example, yesterday, my wife said I could go downtown and spend money. This is a really sexist way of telling this, but I don't know. These ideas pop into my head, so we're just gonna run with it. If anybody's offended, I'm sorry. Tell me afterwards and I'll change it for the next one. The last time around I used M&Ms as my example, and I thought that sounded stupid. So in that example, yesterday she said, you can spend 20 bucks at the bar. Tomorrow I'll give you a penny. Okay. But you can't spend it until I actually give you the whole $20. Well, then 3 days goes by and she gives me another penny. And then 3 more days goes by. 25 years from now, I finally get my whatever, how many pennies? 20 pennies? No, 200? Anyway, I get all the pennies and I have a $20. Can I buy the same amount of goods and services at the establishment with those $20 worth of pennies that I could have if my wife would have just gave me that $20 yesterday, probably not, right? So we were concerned about that, and we were concerned about it because there was about $1.5 billion in backlogs from some of the other 30 Indian water settlements that had existed out there that still weren't paid for, including a couple in Montana, Crow and Blackfeet. So we advocated pretty strongly for, and we were really pleased to successfully negotiate that just under half of the money was actually appropriated with the authorization. So 900 million of the 1.9 billion was appropriated with the enactment of the legislation. It's actually paid to the tribes in 10 installments of $90 million. The first came in 2020, the second for 2021, and now the third installment will come shortly after that. And that money is adjusted to reflect inflation going back to December of 2020. And that took care of about half, just under half, 100 million short, or 50 million short of half the money that was authorized. So that was cool. We were excited about that, but we still knew going forward that before the tribes could spend a significant portion of the settlement funding, that we need to get the rest of it appropriated. And like I said, that had taken some tribes 30 years, and they were getting it doled out in $5 million increments, and that would take a long time to get to $1 billion. So we were successful in working with the Montana delegation, who was really critical in this. I mean, they were sort of the be all end all of this effort, but they were able to get language in the bipartisan infrastructure bill that just passed Congress here a few months ago, back in November or whatever it was, including a provision that basically set up a fund of $2.5 billion that then this would be given to the Secretary of Interior to pay for all of the authorized Indian water settlements that weren't fully funded. And that brings us up to almost today. Just a couple days ago, you might have seen, it was in the paper, the Secretary of Interior last Tuesday, I think, just announced that CSKT would be getting $1 billion of that, just over $1 billion of that of the money that was put into that fund by Congress. So we've been able to check a significant box going forward, in that nearly all of the federal funds are appropriated now. They'll still have to true up the inflation from when they actually deposit the money, the $1 billion, and then there'll still be the incremental $90 million payments that'll happen for the next 8 years going forward, but it's all been appropriated. And that's important because at the end of the day, the federal component of the settlement doesn't all fall into place and get implemented until all the money is appropriated. That's one of the requirements, like I said before, in the example of my wife giving me the pennies. That's the rule for Indian water settlements, is that Congress doesn't generally allow tribes to spend any money until all of it's been appropriated. One of the unique things that we were able to get in this settlement that most tribes don't have the ability to do is authority to spend money on some of the activities that would be carried out under the settlement prior to all of the money being appropriated. In the case of CSKT settlement, those activities include compact implementation, which is really administration and regulation of water rights. Everything that the Water Management Board is doing, measurement activities, resolving disputes, allowing for filing of new water rights permits, all of those types of things are allowed to be expended as soon as they're transferred to the tribes. Secondly, and this is pretty significant amount of chunk of change as well, is that Congress specifically authorized money to be spent as soon as it's transferred to the tribes for purposes of rehabilitating and modernizing the irrigation project, as well as restoring damages to tribal resources that were a result of something caused by the irrigation project. So unlike several other water settlements, CSKT is actually going to be able to engage in rehabilitation and modernization projects on the irrigation project. It doesn't have to wait until the full $1.9 billion is appropriated. So there's a lot of other uses that the tribes can use the money on, such as I mentioned earlier, community water systems. They can use the money to rehabilitate and modernize all the community water systems on the reservation if they so choose, including the scattered home site systems, wastewater systems. They can develop natural geothermal resources on the reservation. They can use some of the money to eradicate noxious weeds reservation wide. There's a number of different uses, but those uses that aren't in the first two categories I mentioned, compact implementation or rehabilitation, modernization, or restoration of damages caused by the irrigation project, all of those have to wait until a certain set of requirements are met under the settlement. And the big one is the appropriation of federal funding. So the big box that needed to be checked is now checked, the federal funding. The other requirements included the tribes, the state, and the federal government all ratifying the compact and making the UMO effective. Those have also happened as well. There's a couple, I guess there's three still remaining boxes to be checked on that front. That is the full funding by the state legislature, which is a much smaller lift. The state contributed $55 million to this settlement, and they've appropriated just under a third of that money so far. So that money will still need to get appropriated. The compact will ultimately need to be decreed by the Montana Water Court, which is a standard process that every compact and every water right holder in Montana goes through. That process is gearing up and will be, it'll be probably a 2 or 3 year process, 3-4 year process probably. But it's mostly, it's a fairly canned process. It gives people the opportunity to provide their comments and feedback, and the judge can then consider all of them. But at the end of the day, the court is considering whether to approve the compact or not. The court isn't going to go back in and rewrite it. And that's the sort of the same process that happens with all settlement agreements. Court doesn't get to tell the settling parties, no, I think you should change this sentence, and I think you should change this sentence. The court either says, I accept the settlement as a whole, or says, go back to the negotiating table, I don't like it. So that has to happen. And then finally, I mentioned the hungry horse storage rights in the compact. The Secretary of Interior has an obligation to sit down with the tribes and work out an agreement for how that process actually works. That's a fairly straightforward process that isn't going to be anything too bumpy going forward. We don't anticipate. So the moral of that story is the sort of the big scary, holy cow, are we ever going to get this done and be able to do any of this work requirement box has been checked. And because we have here what we call early money kind of as our easy way to say it, rather than me talking about appropriations and stuff. The early money is available for compact implementation and rehab, modernization, and restoration for FIP. That work is all already started moving. There's still boxes to check and I's to dot and T's to cross, but a lot of that work is already underway, and you've got people from the Tribal Natural Resources Office who are going to be located at stations throughout, and they can tell you how that's going to work. One of the other things that the settlement did is took care of all the liens that had existed on all the property on the reservation that were tied to the original construction of the irrigation project here. The United States agreed that the Congress agreed to basically lift all those liens. So now they are all gone. Nobody has a lien on their property for the original construction of the irrigation project. And that's the case whether you're an Indian or a non-Indian, whether it's tribal land, non-Indian land, it doesn't matter. Any liens that were there are now gone. They happen by operation of law and were automatic. There's nothing you need to do for that to happen. They're just gone. In addition to that, the Congress allowed for the potential for the irrigation project's management to be modified going forward. And the language of the settlement legislation basically creates three different options really, but they basically fall into two categories. One is that the tribes could undertake operation and maintenance of the project, similar to the way the tribes have assumed all BIA and Indian Health Service functions on the reservation. The only BIA presence here on the reservation outside of the superintendent and her administrative assistant is the irrigation project, the FIP employees. The tribes have through the Indian Self-Determination Act stepped into the shoes of the secretary and now carry out all federal activities on the reservation. So that's one possibility. The other possibility is that there was specific language that allows for the tribes in one or more irrigation districts on the reservation to come together, form an agreement, and then present a proposal to the Secretary of Interior for them to cooperatively take over management and operation of the project. And so for quite some time now, the tribes have been having discussions, very, very positive discussions with the Flathead Indian Irrigation District, or Flathead Irrigation District, where we're at up here. I think, are we still in Flathead or are we in Mission? We're in Flathead, yeah. Where are we right now? With Charlo? We're kicking horse, aren't we? All right. So there have been some very productive discussions going on, but no ultimate decisions made yet on that front. But there is a possibility that going into the future, there could be something similar to, or that has some common attributes of the cooperative management entity that once existed on the project. Whether or not that actually comes to fruition is yet to be determined, but I think there's interest from a lot of folks in addressing some of the challenges that the BIA has had in recent years in operating the project, due significantly in part to the dilapidated condition the project is in, but also due to the higher barriers for hiring and retaining staff that has become sort of ubiquitous across the country, but seems to certainly be a bigger problem for the Bureau of Indian Affairs than really anybody else. So we've got a table here, and I think Chelsea's going to be on Zoom on that if you want to ask her questions on that. Otherwise, is there Shane, is that any other highlights you wanted me to hit, or is this, Rob, have I fulfilled my 20 to 60 minutes of blathering? You did very well. Okay. With that, I got one more joke about Rich Jansen. I'm just kidding. I'm just kidding. I got the mic, right? So I'll be over at one of these tables if you want to ask me any questions, but for anything beyond the general stuff, I think you're probably going to be better off with some of the other experts that are here. So feel free to go visit them. So, Rob.
Thank you, Ryan. This would be the time to invite you to come down to the floor, find the table. The experts will be there, ask your questions, and hopefully it'll be helpful. I'm curious to your feedback afterward. If you like the setup, if you'd like it to change, I'm all ears. So please come on down and let's mingle a bit.